Hello, I'm just getting started.
Hello.
Oh, Anna, you there?
Yes, I'm here.
All right, good. Yeah, we're live now, but we're a few minutes early before the stream started. This is about when I started getting ready last time. About 4 minutes before, I was plugging things in, moving my camera, getting things set up. You left your good webcam at the office.
I did, yes, yeah. So
So
this is just the MacBook camera,
yeah,
but it's not too bad. It might be the light from behind me too.
yeah, that window might be kind of hard behind you. It's okay though.
Yeah, I can turn it.
So we'll wait a few minutes till the scheduled start time. And then I want to start, I'm going to go into Facebook actually and share this. So I can share this some places.
Okay, sounds good to me.
Can you hear the music I have in the background?
Yes, barely though.
Barely. I turned it up a little bit louder.
Yeah, I can hear it now.
Is that annoying or is that too loud?
No,
Good vibes, bad vibes.
Yeah.
Not very professional.
Yeah, I like it.
It is, let's see, I got to make sure I stay in there we go. This way it stays in the camera. I don't know where my mouse is. It's weird. I don't. All right. So we'll when we get started, what we'll do is we'll talk the first little bit about the first half. I have a common topic I want to talk about. I think did you have something prepared? A common question or something that's come up?
Yeah, I was going to talk about revocable and irrevocable trust.
Okay, nice. That's a common question.
Yeah, just touch on them a little bit.
Okay, and then Will might pop in at some point. He's finishing up, or he has a meeting. I think it started at 1. So it depends when he gets finished, he'll join us. And then he has another one too. He's got a busy afternoon. Fridays are typically busy for us. A lot of people like to meet on Fridays. So
yeah, I have I don't know if you can see my calendar yet. I think they're still fixing it, but I have a 3:30 today too.
Okay.
For a design session.
All right, nice. Yeah, Fridays. A lot of people like to get their estate planning done on Fridays, which is good.
Yeah.
So we help accommodate that. People want to get it done. We want to make it easy for them to get it done. So, all right. So we'll go ahead. Is it 2? Is it officially 2 o'clock, or we're about a minute till? We'll wait a little bit. I'm going to share this some places. I'll share this stream. Oh, I see us on Facebook. It's like a matrix. Share page. And then, yeah, so welcome everyone that's tuning in. Thanks for joining us. My name's Rilus Dana. I'm an attorney at Dana & Associates. I'm joined here today with Anna. And today we're going to talk a little bit about some common things that our clients bring to us, common questions that we have. And then we're here to be a resource for you. We want to hear, we want to know what your questions are and how we can help you. So the music that's playing in the background, I don't know if you could hear it or not. We were talking about it if you joined us earlier on the stream. Akira the Dawn, a DJ, inventor of Meaning Wave, which is the music genre where he mashes up podcast and speakers to music. He's done stuff with Gary B, Elon Musk, a lot of others. So it's a cool way, something that I really enjoy as a way to take down information along with music to it. And he's also someone that's inspired me during this quarantine. He started going live every day. So he's in Los Angeles where they're still really locked down. and he just started streaming live every day. So that's part of the motivation for this. I wanted to give something to the community. So that's what this stream is about. This space and time is a time for the community to be there to answer questions, be a resource, and offer our help for people. So if you could share this broadcast wherever you're watching on, if it's Facebook, YouTube, hit a like. That helps more people see it, and share it to someone who could utilize this information. Now, Anna, why don't you go ahead and introduce yourself? So I can turn the screen over to you, actually, if I know how to. And
Okay.
Let's see. I'm going to move.
So my name is Anna Grozdanov. I am an associate attorney at Dana and Associates, and I focus on estate planning, probate, estate administration, so all of that fun stuff. And here to answer any questions that you guys may have for us as well, and just also start a conversation with Rilus so that if you guys don't have questions, maybe some of the topics that we talk about might spark a question that you might have. So that's our goal for today. Hopefully we answer a few questions and get some information out there for people who want to know.
Cool. I'll jump back in here with you. So what is the topic you wanted to go over today, Anna? What is the common question that you want to address?
One of the most common questions I get is, what is the difference between a revocable and an irrevocable trust? So a lot of people come in and they want to know, what's the best one for me? What's the difference between the two? So I think that's a good topic for me to start with. Revocable trust, their name says a little bit about what they are.
Is it revocable or revocable?
It really depends on how you want to pronounce it. Both are correct to me, yeah. I think. I go by revocable, but if you say revocable,
we were kind of joking about this the other day, where I think technically the right pronunciation is revocable. But
yeah, I agree. I think it is too.
I don't think it's in style, right?
Yeah. No.
If you're in
I
CLE,
rarely ever hear people.
But if you hear someone that says revocable, they're actually right, and we're wrong. But
yes,
whatever. Revocable, irrevocable, revocable, tomato.
Yeah.
And this is funny to me.
Potato,
this is one of those topics that I feel is actually not that important, but people get hung up on it, right? Or they
they really do.
And it's I feel like I envision people just at cocktail parties or whatever, just talking to their neighbors, and these are the conversations that they have. And it's do you want a revocable trust or an irrevocable trust? And well, the attorney answer is always, well, it depends, right? Or I'll let you go through and explain it.
Yes.
And then I'll give my short answer of what I tell people they actually want.
Yeah.
So
so it's case by case. So but yes, so revocable trust, you can make changes to it at any point once you create it. So it's revocable living trust. So revocable, you can make changes to it, meaning you can change the trustees down the road, you can change your beneficiaries, you can put assets into it, you can take assets out of it. The assets that you put into it, you still have full control over. So that is really what the revocable trust is. Living while you're living, you can.
Yeah, with revocable trust, another way I explain it, or I guess another way to say the same thing, is that if you can freely get to it and change it, so can your creditors. Right? So
yes.
The good part about the revocable trust is all that flexibility. You still maintain all the control of the assets, and that's what most people want. That's where every plan starts with the revocable trust, right? And then some people need an irrevocable trust on top of that for other specific purposes.
Yeah, exactly. Exactly. Yeah. So that's a potential drawback of the revocable trust is that they do not protect against creditors, judgments, Medicaid. So if you wanted to get public benefits in the future, they don't protect your assets from that. They don't protect from estate taxes. But currently, the estate tax is 11 million for a single person, 22 million for a couple. So a lot of people don't really meet that or don't exceed that exemption. So that's not really a worry these days. Whereas in the 90s, that used to be a big reason for why people would get irrevocable trust. And so that kind of leads me into irrevocable trust. When you create an irrevocable trust, once you put your assets into it, you no longer own those assets essentially. So when the estate tax exemption was, let's say, only 600,000 in the 90s, a lot of people wanted to get that irrevocable trust created, put some of their assets into it so they could protect from having to get hit with that estate tax if they went over that 600,000. And it was a big estate tax. It's, 40% or more of your estate being taken. So that's why people used to create irrevocable trusts. That's why they were so common, I would say, back in the day. But now people move more so towards revocable.
Yeah. So revocable. So what does revocable mean?
It means that they can revoke the trust fully. They can make changes to it if necessary, but
so make changes and full control. So
yes, yeah, full control of it.
Now, okay. And so the basic trust that people create to avoid probate is a revocable trust. So that way they can maintain control of their assets.
Yes, yeah.
Now, what happens after they die? Is that trust still revocable?
No, so a revocable trust does turn into an irrevocable trust once the trustors pass. So at that point, it becomes irrevocable. So that way their successor trustees can't step in and start making changes to the provisions that they've included and can't change their beneficiaries or anything like that. So the successor trustee just manages the trust, but they can no longer change it. So it does become irrevocable at that point.
Yeah, so that can be kind of confusing. It can be really confusing because sometimes trusts are named like the Smith Revocable Trust, but when we're administering them, like after they passed away, when we get the tax ID number, you got to check a box and say, is this an irrevocable trust? So it's the Smith Revocable Trust, which is an irrevocable trust after both Smith creators pass away. So I don't use the name revocable, as part of the name of the trust because it can get confusing once they go into irrevocable trust. So, all right. So the trust is irrevocable after the trust creators, which we call the trustors. Some attorneys call them the settlors, the grantors, the trust makers. We call them the trustors. But after they pass away, it becomes irrevocable. We got a couple of questions here. Let's see, and kind of go through. Let's put them on there. Here's Tristan. Thanks for watching, Tristan, tuning in. I have a question for the right time. I have a revocable living trust, and I need to make an existing corp beneficiary of the trust, and then create a new LLC to have the corp as a beneficiary. I'm not sure what you're asking. Here's your other one. So you want to retain anonymity. I can't say that word, but I know what you mean. Not sure if I missed the boat and need to start over. All right, good point, Tristan. I'm not sure exactly what you're asking there, but one thing you can do in an irrevocable trust sometimes is you can create anonymity, meaning that it's not clear who the owner of a trust is. I think a better tool for what you're doing might be with an LLC in a state like Nevada or Wyoming that keeps the information of the owners private. Now in Arizona, when we transfer land into a trust, we have to record who the beneficiaries of the trust are. So they're not a good tool in Arizona. I'm not sure where Tristan's located. I think he might be out of state. So maybe that's why he's asking that question. And then Linda Childers, can any family member change the revocable trust? No. Well, maybe.
It
So
depends.
that's always the attorney answer, right? Who's my client, right?
Yeah.
Who's hiring us? But no, generally, so the revocable trust can only be changed by the trustors, the people that create it. After they pass away, it becomes irrevocable. So family members can't change it. I said depends and maybe. It's because there's another topic. This is one of my favorite topics. It's called decanting. So decanting it's a wine term. It was a wine term first, and the legal world has adopted it to decanting is a way that you can change an irrevocable trust without the court, without judicial involvement. So that's a new tool that we can utilize when we have an irrevocable trust that there's a problem with. So this came up the other day, didn't it, Anna? This decanting.
Yeah. Mm-hmm.
So do you want to share the general scenario of how it came up the other day?
Decanting for an irrevocable trust?
Yeah.
Or the issue that we were talking about a few days ago? The trustees that were appointed for that irrevocable trust were getting a little bit up there in age, and they were no longer really wanting the responsibility of having to distribute the assets, and they kind of wanted to, I guess, resign as trustee, but they also wanted to appoint somebody else who wasn't listed as a successor trustee through the trust. So that was the issue there, and we're trying to figure out a way to get a new trustee appointed through the decanting process.
Yeah, so decanting, it's a way that we can clean up and fix mistakes or fix problems in these irrevocable trusts. So it's really cool. It's a really neat thing. It gives some more flexibility to your plan. And I've seen it come up that way a few different times where no one wants to be the trustee of a trust. So and the trust doesn't appoint anyone. So instead of going to court and asking the judge what to do, you can have the trustee, the old trustee, appoint it to a new trustee. So the wine term decanting means you pour from one barrel into another barrel. So you can see why they adopted it in the legal world. You pour out of one trust and into the new trust. That's fixed, doesn't have any problems with it. So Tristan's asking some other questions about LLCs and stuff. Tune in tomorrow, Tristan. I'm going to be going live on the Mott Legal channel at 10:30, and I'll talk more about the business stuff. So today I want to keep it more about the estate planning side and how to set that up. Okay, so revocable, irrevocable. So the way this question comes up a lot, people will call and they'll say, I want an irrevocable trust. Or, in our planning sessions,
Mm-hmm.
they'll say, so-and-so told me that I want an irrevocable trust. What's your answer to that?
Mm-hmm. First, I would explain the difference between the two to them, and then state that if they need an irrevocable subtrust or an irrevocable trust, we can
irrevocable
do it for
subtrust.
them,
Let's talk about that. So what I tell them is what you really want is you want someone that creates an irrevocable trust for you. That's the magic. That's what you
Mm-hmm.
want. Right now, if you create an irrevocable trust, you're going to have to give up the control of your assets, generally, so to speak.
Yeah.
There's some advanced ways that we can do this in Nevada and things like that, but it's usually cost prohibitive unless you're giving at least $1 million at a time into these types of trusts. So it's a little bit more expensive for those strategies. But let's talk about subtrust. I just shot a video about this yesterday with Bobby. Shot a bunch of videos, like 7 or 8. But there'll be one coming out explaining what subtrusts are. So a subtrust is, how would you describe a subtrust, Anna?
It is a trust that is created upon the passing of the trustors to do a certain task that they want, essentially.
Good.
So let's say
a trust
pet
created
trust,
within
for
a trust.
example. Yeah, a trust within a trust. Yes, yeah.
And the answer I came up with yesterday on video that I think I liked, we'll see if it makes the edit or not. I said subtrusts are the trusts that your trust creates for your kids. So we have what we call the master trust.
Mm-hmm.
People create a revocable trust. And then after they pass away,
Mm-hmm.
the subtrust shows what the conditions are. And the most common subtrust is what we call an age restriction trust. Hold it for the beneficiary until they turn age 18, or give them 1/3 at age 20, half at 25, and the balance at age 30. So that's an age subtrust. Now another subtrust is a dynasty trust. So a dynasty trust is an irrevocable trust. So it's an irrevocable trust that the kids inherit. And instead of the children receiving their inheritance outright, they receive it inside of an irrevocable trust. And they can control this irrevocable trust. The magic of that is that it's created by the parents. Because the parents create the trust, they can give it to their children inside of an irrevocable trust. And that gives children the asset protection, and it still allows them to have the control of it as well. And we can choose when they get the control. So when people say, do I want a revocable or irrevocable trust? My short answer is, you want someone to create an irrevocable trust for you. That's the dream. That's that's like the heiress dream, right? Where you have a trust fund and it's protected. I see Will's in the studio. Let's get him in the stream. So, hello, Will.
Hello, Rilus. Hi, Anna. How's it going?
So, good. Thanks for joining us.
Yeah, it's good to see you guys virtually.
Yeah. So you're out doing work, huh? Seeing clients?
Yeah, just finished an execution. It went well, so that was good. We're doing
execution.
That.
What happened? We're gonna start calling those signing meetings. So execution. It sounds so brutal, huh?
I know, right? I didn't kill anyone. We just talked about forms.
Yeah, just sign documents.
Yeah.
So that's good. So Anna introduced herself briefly. Let's we'll give you we'll turn over the stream to you. We'll give you some your time to shine a little bit, but I'll have you just introduce yourself and say who you are. And we talked about irrevocable versus revocable trust. That's a common question that Anna brought up. And I think you had something prepared as well today, didn't you? So you can.
Yeah. Well, first of all, I'm Will, and I'm an associate at Dana and Associates. I've been here since January working with Rilus. I'm fairly new law school graduate. I finished last year, took the bar in Arizona in July. I graduated law school last May, so I'm fairly new, although I've been working in the legal field as a paralegal for about 12 years doing immigration law prior to going to law school. So I went to law school in Arkansas, University of Arkansas at Little Rock. And so moved back to Arizona after I passed the bar and started with Dana, and been loving life ever since. Then this pandemic hit, and now I work virtually most of the time, and I barely get to see these guys except for on the phone and the computer. So. But the one thing I wanted to talk about was something my clients have been asking me. I had a couple phone calls this week, and that was about how to transfer title to a vehicle upon one's death. So there's a lot of different ways to do that. So we routinely get this question, where do I have to do something with the title of my cars? And the answer is, it depends. It's kind of
always our answer, huh? That's why people love attorneys. We just give straight answers. And
I know. And so I guess what I tell them.
That's why we're hosting this stream, though, too. We're creating a space where we can have those conversations, because there's not always just one answer. So, and it's not always the same easy answer for everyone.
Yeah, exactly. And it really kind of depends on who you are, how your cars are titled, and who your beneficiaries are, if you're married or not. And so the answer can be different for different people, really. But
yeah, I had a consultation. I think we did this. This is on some of our social media. But I was like, oh, cars, I usually don't worry about them. And he's like, did you see what it was on there? And I was like, let me go back to the inventory. And it was like $1 million Ferrari or something. So I was like, oh, wait, that type of car, maybe we should plan for that one.
Yeah.
So
yeah, sometimes people have a Ferrari that's worth more than I'll ever see. And, then they definitely want to account for that. So I think generally we aren't as concerned with cars, because if their probate estate is under 75,000, then they can typically get transfer taken care of using that personal property affidavit.
Yeah, so we're not concerned because my experience, I haven't seen cars cause an issue with probate. Now, there's been states I've seen where they're well over 75,000, all the vehicles they have, but the DMV has allowed them to transfer the vehicles.
Yeah.
So it's just one of these things where I've seen people get tripped up in a lot of different things, and that's what we're telling them, hey, this is what you do need to worry about. But as far as cars and probate, that's usually not the issue.
Yeah, and when we say, probate estate, that's things that aren't controlled for by your trust and through beneficiary designations. So it's things that are in people's name individually. So that total needs to be under 75,000 typically.
Yeah.
And in that event, you can go to the DMV with that personal property affidavit and get title released to the heir.
Yeah. So what are options for people when they're planning for cars? So they have some cars, whether it's a Ferrari or maybe it's another sentimental car. It could be like a $2,000, I don't know, whatever, but it's sentimental.
Yeah. So a lot of times what people do first is they, if they have title, they can have it jointly owned, and that's what some people are happy enough just doing that. And the DMV
so
gives you.
That's common with a spouse, but what if they want to give their car to a kid? Should they own it jointly with their kid?
No, well, owning it jointly, as I'm sure you well know, opens the door to some liability where they could be exposed if if whoever they own it jointly with is sued or something. But yeah, that is one way to avoid probate and transfer title, as long as there's right of survivorship. So for instance, you could have on your title John Smith or Jane Doe, and that way, whichever one passes, the other one would be able to sell that vehicle without the other signature. So that's something that the DMV would let you do by having a car be jointly owned.
Yeah. What other options do people have? So Nikki asked a good question here.
Would you recommend transferring a beneficiary designation form? And yes, that's exactly what I was going to recommend at some point here. And that is the form that DMV allows you to fill out, say who you want the car to go to upon your death, and then you sign and notarize it and attach it to your title. So you could do it to, say, your children, or sometimes you can even do it to where you can name your trust as the beneficiary. So that way you'd have one person, your successor trustee, take over the vehicle upon your death and split the proceeds through the trust.
Yeah, so I've seen estates where there's a collector vehicle of some sort, and maybe that's like the only large asset in the estate. So what we end up doing is transferring that to the trust. And then that way the trust can organize the sale of it and divide it between the beneficiaries.
Right. And the trust could own the vehicle, and that would be you could take the title to the DMV and put the vehicle in the name of the trust, so that would happen easily upon death.
Yeah. And then what's another option for vehicle? There's one more option I can think of that we haven't talked about yet. If you want to specify who gets a vehicle. Sentimental.
You mean through your will, if you want to give
There
it
we
as
go.
a specific gift? So you could, put in your trust or your will who it goes to as a specific gift before it's split, let's say, between the children.
Yeah, so that's a good way if it's a sentimental vehicle or if there's several vehicles where they, want so-and-so to get, the Corvette and the
My Ferrari to Will Grace because he's
Ferrari to Will,
estate
and it
tenant.
gets the Mercedes. So,
Yeah.
vehicle's good. So Anna and I talked about revocable and irrevocable trust.
Oh, nice.
That's vehicles. I have a topic ready too. So I have a common question that I want to talk about, something that comes up quite a bit. The question I want to talk about is about co-trustees. So can you have multiple trustees? Can you have co-trustees? Can you have 2, 3, 4 people be the trustees at the same time? Do you guys ever get that question, Will, Anna?
Oh yeah, all the time.
So,
all the time. Yeah.
I said, yeah, can you? Yeah, but should you is a better question to be asking. Right. So let's break this down a little bit. So there's a lot of people that I call that are order takers. There are a lot of attorneys, document preparers that whatever you tell them, they'll do it. And also the LegalZoom world and just the do-it-yourself, the fill-in-the-blank world, you can add as many co-trustees if you want. I'm sure a lot of those places. But just because you can, should you? Now, so last Saturday I did a live stream for Mott Legal. We had a guest on, and she asked, "How do I find an estate planning attorney?" She was in New York, and I said, she said, "What do I need to do to find an estate planning attorney?" And I said, "Well, first, make sure that they also practice in the probate and trust administration, that they know how it works after people pass away, because that results in better planning. Because as a result of our administration and probate experience, we see the messes that come when people name co-trustees, 2 trustees, 3 and 4. And if these people can't get along during their lives, or I think the idea a lot of people have, and order takers will just do it, is that they take 2 kids. If there's husband and wife, they each have kids from a prior relationship. They say, hey, let's just name each one of our kids to be in charge of this. Yeah. And that way they can sort out their competing interests by both being in charge of it. And then they got to figure out together how to sell mom's lake house or whatever it is. It's the family's pride and joy. Or
half of them sell and half of them don't.
Yeah, and they're both right. They both could be good options. So as a trustee, you have a fiduciary duty to do what's best for all of the beneficiaries. So there could be a situation where there's, a couple of good choices, but what do you do if there's not a tiebreaker? So I don't recommend co-trustees in most circumstances. We had a probate. It drug on several years. There was 3 kids, didn't get along, and they were all named as a personal representative. And young Rilus agreed to represent them on the condition that they would all get along and all cooperate. No, it didn't work. it didn't work. They all were, I thought we could just kind of move, take the emotion out of it. Step 1, let's file it. Step 1, sell the house, whatever. But oh man, there was this has happened a lot. Other estate attorneys, I'm sure they get this too, where you have family members all in your conference room, and you have to just like referee basically. Be nice to your sister. No, don't. Nice to your brother. And it's it's like the same thing I do with my kids too. My kids that are ages 8 to 13, and these beneficiaries are usually double my age a lot of times, but I'm having to babysit them. So, do you guys have any experience, Will or Anna, with co-trustees?
Yeah, I mean, it seems like I get asked that same question a lot. And a lot of times, the parents, they're conflicted because they don't want to put one ahead of the other. They love their kids equally, and it's tough for them to choose. But really, I like to say that they're doing this for the kids so that, it's less administrative work. So they don't have so many people needing to sign everything. And then one could resign and let the other take over if they're not in a good position to do their job. So let's say they put child A as the first successor trustee and they move to Russia or China or something, they could always resign and let number 2 step in. So
yeah, that's a great point you bring up, Will, the flexibility.
Yeah.
So good planning is about options. So whenever there are co-trustees, like after someone's passed away, I'll usually present that to them and say, you know what, if one of you is better suited to manage it, the other one of you can resign. And a lot of times people will end up doing that, just depending on where they're at in life, how much time they have, where they're located geographically, depending on, who's better suited, they let the other one take over.
Who's less busy might be a deciding factor. Yeah.
So,
and I think that sometimes people don't realize too that they can have other options as trustees. It doesn't just have to be your kids, especially if, they don't get along or they don't really know each other that well. If they're step siblings, I mean, there's fiduciary companies. You can have friends do it. You can have siblings do it. I know a fear of having your sibling do it is that they might be the same age or older than you. So people worry about that. They want to have younger trustees, but there are other options out there too to make the trust administration simpler.
Yeah. Other options is one thing I want to talk about. And then another thing, the older I want to touch on before I get to the other options. A lot of times people, they think that they got to name everyone that's younger than them, right? When they're choosing trustees, we're like, well, this person's good, but they're older than me. Yeah. So we say, choose the best person today. If something were to happen to you today, who's the best person right now? And that should be your number one choice. Now, if they are old and you're worried that they're not going to be the best choice in the future, that's why you name a backup, at least one other option. And I recommend at least 2. And I tell people if they want to give us 3, I'm cool with that, but we don't necessarily have to do 3 because I want you to come in about every 5 years to look at everything to keep it current. So yeah, the options. Now I popped up on the screen this powered by Mott Legal to talk about options as far as fiduciaries. So Mott Legal is our parent company that manages the law firm, and it offers estate planning services to other attorneys. It also has a fiduciary company. So I ended up offering those services through Mott Legal. It's something that I debated for a while whether I wanted to offer that or not to our clients, but so many people have asked us for it. There's been a lot of people that they don't have a family member. They want someone independent. So then what are your choices? So as far as a fiduciary company, there's some other ones that I work with as well. There's some local fiduciary companies that can be good, but banks, a lot of banks don't really want to be trustees anymore. They don't want to be trustee unless they're managing at least $5 million in assets, and they won't. Some banks will tell you that straight up. Other ones, they not so much, but their minimum fees are usually pretty high. And my other complaint about the big banks as trustees is they don't have local departments. So here in Arizona, if you name some of the big departments or some of the big banks, their trust department is out of California somewhere. So you don't get the local service, and they're kind of detached from it a little bit. Again, unless there's more than 5 million in assets, and then you get some more attention. So who do you go ahead, Will?
How do these fees work with these big companies? That's the question I get asked a lot is, if I name a fiduciary company, even if it's a bank in California, how do they charge my estate when I'm gone? It's really what I see.
Good question. Another reason why I took on the the fiduciary, serving as a fiduciary, is so I could show people what our fees are. Because it can be very tough just to figure that out. So if you're interested in having a bank or someone serve as a trustee, what are the fees? And if you call them, a lot of times they're not very open about it. They say, yeah, just come in and talk to us. Or they may quote you, they may say, oh, it's only 1% to serve as a trustee. But there's another fee called estate settlement, which is the fee to settle the estate after someone passes away. That's usually a lot larger fee. So Mont Legal, we have a nice fee schedule. It's very straight up, very clear. So I let people, when people are searching for fiduciaries, I say, here you go. Here's something to go off of. You can see what our fees are, and this gives you something to compare. So talk to your bank, talk to your places, and then the other thing you got to consider, you're really choosing that company or that institution, because they all have the power to change the prices in the future. I've been listening to a lot of financial podcasts lately, just the news, just trying to see what's going on, just trying to figure out what's going on. And something I heard yesterday is they're saying, be prepared to pay more bank fees. These banks are going to be looking for ways to make money, because there's a lot of people that aren't paying their mortgages because they're allowed to forbear for about a year or so, it looks like. So they said, be prepared to have, look for all these different fees. So trustee fees, something I've seen. I've seen big banks or these big companies, they waive really low trustee fees as a way for people to move their money over there. They say, come to blank, come let us manage your money. And as part of the benefit, we'll serve as your trustee for basically nothing. That's the plan today. But
what's
that
price
in the future?
Yeah.
So, good question though about good topic about the trustees and the fiduciaries.
Yeah.
All right. Just any final thoughts? We want to wrap this up. The other kind of latest news we can tell people or we can talk about for the last little bit. We've been working hard in adjusting to the virtual life, haven't we, guys?
Sure have. Yeah.
Mm-hmm. Yes.
So
we're here on a video, online video conference. That's kind of how our lives are now. Yeah.
Yeah, that's how our lives are. Anna just joined us here pretty recently, but Will was a part of the transition to the virtual life, and the creator of the flyby signings.
That's right.
That's part of it. So since we can't meet people in person, we're trying to adjust. How can we offer our services? How can we help people virtually? So I really appreciate the flyby signing. And I've been hard at work creating better materials for better client meetings virtually. The PowerPoint presentation. So we have materials that we can show people, adjusting our fee agreements and all of our diagrams and tools that we use so that they can be used in a virtual meeting. And now the exciting thing that's coming. So the flyby signings, let's talk about those. So that's where, explain the flyby, Will, and tell them how the new updated flyby is going to work.
So we were looking for a way to keep ourselves safe as well as our clients safe during the pandemic outbreak is really what happened. And for the most part, we adopted to the first meeting fairly easily because we're able to meet with clients for their initial just over a video conference. But what happened was we didn't know how to safely have them sign all of their legal documents, their will and their trust and their powers of attorney, especially considering the formalities in place with wills where we need to notarize and we need to witness people sign. So what we sort of did was start going through people's forms virtually first so we can finalize them and answer any questions and make them in accordance to their wishes. And then we have them come and sit down at a little conference table outside of a window to our conference room. And then we put sticky notes everywhere they're going to sign. And that way we can witness them sign. And it only takes a few minutes. They just come up to our office. We put the forms out on a little table outside our window. We put stickies everywhere they're going to sign. They just need to sign quickly. And we snap a quick picture of their driver's license so we can notarize them. And so I think what we're going to change is let them come in our conference room now, because it's getting so hot. We're hoping the pandemic cools and, we come out of it. And so we're going to keep people safe, us safe with social distancing, but you can actually come inside our office now as opposed to sit outside.
Yeah, when it got to be too hot for me, just walking from my car, it's like, yeah, it's too hot to stand outside. We can't have people outside the office.
Yeah, we don't. Yeah, we don't want to torture people in the heat.
So the flybys got moved into the conference room, and then we just we're lucky the way our office is set up, so we can be back a safe distance. So what we do, we can have it ready for just one person at a time to come to our conference room. And then they come in, their documents are waiting for them. They sign, they leave. We sanitize. We put in hard chairs there instead of our other leather ones. So they're easier to sanitize and clean.
Yeah, and so we really get to do everything virtually, except for just having them come in and sign, and that way we can maintain safe distances.
Yeah. So part of this virtual meeting and the flyby, we've shifted our process to do the document review in that virtual meeting. That used to be done in person, and then if everything was to their liking, then they would sign. So something that's been a nice blessing out of this is I really like those virtual meetings. I think they're more effective than the in-person.
Yeah, it saves paper too, because if there's any little change, we just make it right then and there with them.
A lot of paper because of that reason. It takes the pressure off too, which is nice, because you're not going to sign them that day.
Yeah.
Right. That we're just looking at them together. We're making sure that they do exactly what's wanted.
Yep.
And then after they're ready to go, after they're approved, we mark them as final. So then people can kind of lock it in so they don't feel rushed. Because some days they may end up changing some things right then. So I actually don't want that person there, or actually I want to adjust this percentage.
Yeah.
So it gives a little time where it's locked in. And then when they come in to sign, whether that's a flyby or whatever it is, they've already reviewed everything thoroughly with the attorney at that point.
Right.
So it's just the formality.
Yeah, they're comfortable. And it keeps us from having to run in and out of the conference room to make changes or something like that too.
Yeah. So those meetings are great. And we're looking at ways. Well, we're trying to decide, when do we invite the clients back in, right? When do we go back to that kind of world? But even when we go back to that kind of world, how do we make the most efficient experience for people? So I think we're still going to recommend keeping that virtual, what we call the virtual execution, which is where we just review all the documents with the attorney together. Mm-hmm. And then the signing could either be a flyby or remote notary. I got approved last night. My license is the last step was through Doc Verify, the company that I'm going to be using to provide the technology, and that got approved last night. So I'm ready. I can notarize stuff electronically, and I think
we'll never have to leave your house again pretty soon.
No, I may never leave again. So.
That's exciting. Yeah.
Yeah, we'll be adding that into our process, the remote electronic notarization. So that'll be an option for people in the really near future here. So, okay. So any final closing thoughts? We talked about the flyby. We talked some about the virtual meetings, how we shifted to that. There's a video. I believe it's going to be out next week, and it may be out if it's not already. Yeah, it's coming out Wednesday. I think I saw it on the preview for next week's calendar. It's about how to make your own will, how to do your own handwritten will. So for the people watching this, that especially the people that have a significant other that they're not legally married to, have children that maybe they're stepchildren that aren't legally adopted. Or they're not close with their family members, those people, I wanted to show them how they could do a will at home on their own. So that's going to be on our on our social media pages. And then this space as well. So we're doing it at Fridays at 2 throughout May. So tell your friends, share this with them. If they have questions they want us to discuss on the show, they can send us an email before. You can always make a comment during the show. We like that. But if they don't want to show people who they are or what their question is, they can email us ahead of time. And the topic next week that I want to talk about is what the kids should do, what the trustees need to know after mom and dad pass away. So that's a question I get quite a bit from clients when they're setting up their plan. They say, hey, what do I tell my kids who are the trustee? What do they need to know? And then for the children who are stepping into that role for their parents' plan, maybe their parents are their health is starting to decline. So we need to do what we call a living trust administration. Or after they pass away, what is that going to look like? How are they going to referee the family, basically, right? How are they going to manage the estate and the trust? So that'll be the topic for next week. So any closing words, Anna, Will?
Not for me. Just stay healthy, keep carrying on, keep doing what we're doing.
All right, we'll close with that.
Yep.
Thanks, guys. Have a great day. Thanks for tuning in.
Absolutely. Thanks,
Thank
Rilus.
you, everyone.
Take care. Bye, everyone.